Kentucky v. King, Supreme Court, 2011. Justice Alito delivered the opinion of the court. It is well established that exigent circumstances, including the need to prevent the destruction of evidence, permit police officers to conduct an otherwise permissible search without first obtaining a warrant. In this case, we consider whether this rule applies when police, by knocking on the door of a residence and announcing their presence, cause the occupants to attempt to destroy evidence. The Kentucky Supreme Court held that the exigent circumstances rule does not apply in the case at hand because the police should have foreseen that their conduct would prompt the occupants to attempt to destroy evidence. We reject this interpretation of the exigent circumstances rule. The conduct of police prior to their entry into the apartment was entirely lawful. They did not violate the Fourth Amendment or threaten to do so. In such a situation, the exigent circumstances rule applies. 1. This case concerns the search of an apartment in Lexington, Kentucky. Police officers set up a controlled buy of crack cocaine outside an apartment complex. Undercover officer Gibbons watched the deal take place from an unmarked car in a nearby parking lot. After the deal occurred, Gibbons radioed uniformed officers to move in on the suspect. He told the officers that the suspect was moving quickly toward the breezeway of an apartment building, and he urged them to hurry up and get there before the suspect entered an apartment. In response to the radio alert, the uniformed officers drove into the nearby parking lot, left their vehicles, and ran to the breezeway. Just as they entered the breezeway, they heard a door shut and detected a very strong odor of burnt marijuana. At the end of the breezeway, the officers saw two apartments, one on the left and one on the right, and they did not know which apartment the suspect had entered. Gibbons had radioed that the suspect was running into the apartment on the right, but the officers did not hear this statement because they had already left their vehicles. Because they smelled marijuana smoke emanating from the apartment on the left, they approached the door of that apartment. Officer Stephen Cobb, one of the uniformed officers who approached the door, testified that the officers banged on the left apartment door as loud as they could and announced, "This is the police," or "Police, police, police." Cobb said that as soon as the officers started banging on the door, they could hear people inside moving, and it sounded as though things were being moved inside the apartment. These noises, Cobb testified, led the officers to believe that drug-related evidence was about to be destroyed. At that point, the officers announced that they were going to make entry inside the apartment. Cobb then kicked the door. The officers entered the apartment, and they found three people in the front room: Respondent Hollis King, Respondent's girlfriend, and a guest who was smoking marijuana. The officers performed a protective sweep of the apartment, during which they saw marijuana and powder cocaine in plain view. In a subsequent search, they also discovered crack cocaine, cash, and drug paraphernalia. Police eventually entered the apartment on the right. Inside, they found the suspected drug dealer, who was the initial target of their investigation. 2. Although the text of the Fourth Amendment does not specify when a search warrant must be obtained, this court has inferred that a warrant must generally be secured. It is a basic principle of Fourth Amendment law, we have often said, that searches and seizures inside a home without a warrant are presumptively unreasonable. But we have also recognized that this presumption may be overcome in some circumstances because the ultimate touchstone of the Fourth Amendment is reasonableness. Accordingly, the warrant requirement is subject to certain reasonable exceptions. One well-organized exception applies when the exigencies of the situation make the needs of law enforcement so compelling that a warrantless search is objectively reasonable under the Fourth Amendment. This court has identified several exigencies that may justify a warrantless search of a home. Under the emergency aid exception, for example, officers may enter a home without a warrant to render emergency assistance to an injured occupant or to protect an occupant from imminent injury. Police officers may enter premises without a warrant when they are in hot pursuit of a fleeing suspect, and, what is relevant here, the need to prevent the imminent destruction of evidence has long been recognized as a sufficient justification for a warrantless search. Over the years, lower courts have developed an exception to the exigent circumstances rule, the so-called police-created exigency doctrine. Under this doctrine, police may not rely on the need to prevent destruction of evidence when the exigency was created or manufactured by the conduct of the police. In applying this exception for the creation or manufacturing of an exigency by the police, courts require something more than mere proof that fear of detection by police caused the destruction of the evidence. An additional showing is obviously needed because, as the Eighth Circuit has recognized, in some sense the police always create the exigent circumstances. That is to say, in the vast majority of cases in which evidence is destroyed by persons who are engaged in illegal conduct, the reason for the destruction is fear that the evidence will fall into the hands of law enforcement. Destruction of evidence issues probably occur most frequently in drug cases because drugs may be easily destroyed by flushing them down a toilet or rinsing them down a drain. Persons in possession of valuable drugs are unlikely to destroy them unless they fear discovery by police. Consequently, a rule that precludes the police from making a warrantless entry to prevent the destruction of evidence whenever their conduct causes the exigency would unreasonably shrink the reach of this well-established exception to the warrant requirement. Presumably for the purpose of avoiding such a result, the lower courts have held that the police-created exigency doctrine requires more than simple causation, but the lower courts have not agreed on the test to be applied. 3. Despite the welter of tests devised by the lower courts, the answer to the question presented in this case follows directly and clearly from the principle that permits warrantless searches in the first place. As previously noted, warrantless searches are allowed when the circumstances make it reasonable, within the meaning of the Fourth Amendment, to dispense with the warrant requirement. Therefore, the answer to the question before us is that the exigent circumstances rule justifies a warrantless search when the conduct of the police preceding the exigency is reasonable in the same sense. Where, as here, the police did not create the exigency by engaging or threatening to engage in conduct that violates the Fourth Amendment, warrantless entry to prevent the destruction of evidence is reasonable and thus allowed. Some lower courts have adopted a rule that is similar to the one that we recognize today, but others, including the Kentucky Supreme Court, have imposed additional requirements that are unsound and that we now reject. Bad faith. Some courts, including the Kentucky Supreme Court, ask whether law enforcement officers deliberately created the exigent circumstances with the bad faith intent to avoid the warrant requirement. This approach is fundamentally inconsistent with our Fourth Amendment jurisprudence. Our cases have repeatedly rejected a subjective approach, asking only whether the circumstances viewed objectively justify the action. Indeed, we have never held, outside limited contexts such as an inventory search, or administrative inspection, that an officer's motive invalidates objectively justifiable behavior under the Fourth Amendment. The reasons for looking to objective factors rather than subjective intent are clear. Legal tests based on reasonableness are generally objective, and this court has long taken the view that even-handed law enforcement is best achieved by the application of objective standards of conduct rather than standards that depend upon the subjective state of mind of the officer. Reasonable foreseeability. Some courts, again, including the Kentucky Supreme Court, hold that police may not rely on an exigency if it was reasonably foreseeable that the investigative tactics employed by the police would create the exigent circumstances. Courts applying this test have invalidated warrantless home searches on the ground that it was reasonably foreseeable that police officers, by knocking on the door and announcing their presence, would lead a drug suspect to destroy evidence. Contrary to this reasoning, however, we have rejected the notion that police may seize evidence without a warrant only when they come across the evidence by happenstance. Adoption of a reasonable foreseeability test would also introduce an unacceptable degree of unpredictability. For example, whenever law enforcement officers knock on the door of a premises occupied by a person who may be involved in the drug trade, there is some possibility that the occupants may possess drugs and may seek to destroy them. Under a reasonable foreseeability test, it would be necessary to quantify the degree of predictability that must be reached before the police-created exigency doctrine comes into play. A simple example illustrates the difficulties that such an approach would produce. Suppose that the officers in the present case did not smell marijuana smoke and thus knew only that there was a 50% chance that the fleeing suspect had entered the apartment on the left rather than the apartment on the right. Under those circumstances, would it have been reasonably foreseeable that the occupants of the apartment on the left would seek to destroy evidence upon learning that the police were at the door? Or suppose that the officers knew only that the suspect had disappeared into one of the apartments on a floor with 3, 5, 10, or even 20 units. If the police chose a door at random and knocked for the purpose of asking the occupants if they knew a person who fit the description of the suspect, Would it have been reasonably foreseeable that the occupants would seek to destroy evidence? We have noted that the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. The reasonable foreseeability test would create unacceptable and unwarranted difficulties for law enforcement officers who must make quick decisions in the field, as well as for judges who would be required to determine after the fact whether the destruction of evidence in response to a knock on the door was reasonably foreseeable based on what the officers knew at the time. Probable cause and time to secure a warrant. Some courts, in applying the police-created exigency doctrine, fault law enforcement officers if, after acquiring evidence that is sufficient to establish probable cause to search particular premises, the officers do not seek a warrant, but instead knock on the door and seek either to speak with an occupant or to obtain consent to search. This approach unjustifiably interferes with legitimate law enforcement strategies. There are many entirely proper reasons why police may not want to seek a search warrant as soon as the bare minimum of evidence needed to establish probable cause is acquired. Standard or good investigative tactics. Finally, some lower court cases suggest that law enforcement officers may be found to have created or manufactured an exigency if the court concludes that the course of their investigation was contrary to standard or good law enforcement practices or to the policies or practices of their jurisdictions. This approach fails to provide clear guidance for law enforcement officers and authorizes courts to make judgment on matters that are the province of those who are responsible for federal and state law enforcement agencies. For these reasons, we conclude that the exigent circumstances rule applies when the police do not gain entry to premises by means of an actual or threatened violation of the Fourth Amendment. This holding provides ample protection for the privacy rights that the amendment protects. When law enforcement officers who are not armed with a warrant knock on a door, they do no more than any private citizen might do. And whether the person who knocks on the door and requests the opportunity to speak is a police officer or a private citizen, the occupant has no obligation to open the door or to speak. When the police knock on a door, but the occupants choose not to respond or to speak, the investigation will have reached a conspicuously low point, and the occupants will have the kind of warning that even the most elaborate security system cannot provide. And even if an occupant chooses to open the door and speak with the officers, the occupant need not allow the officers to enter the premises and may refuse to answer any questions at any time. Occupants who choose not to stand on their constitutional rights but instead elect to attempt to destroy evidence have only themselves to blame for the warrantless exigent circumstances search that may ensue. 4. We now apply our interpretation of the police-created exigency doctrine to the facts of this case. We need not decide whether exigent circumstances existed in this case. Any warrantless entry based on exigent circumstances must, of course, be supported by a genuine exigency. The trial court and the Kentucky Court of Appeals found that there was a real exigency in this case, but the Kentucky Supreme Court expressed doubt on this issue, observing that there was certainly some question as to whether the sound of persons moving inside the apartment was sufficient to establish that evidence was being destroyed. The Kentucky Supreme Court assumed for the purpose of argument that exigent circumstances existed, and it held that the police had impermissibly manufactured the exigency. We, too, assume for the purposes of argument that an exigency existed. We decide only the question on which the Kentucky Supreme Court ruled and on which we granted certiorari. Under what circumstances do police impermissibly create an exigency? Any question about whether an exigency actually existed is better addressed by the Kentucky Supreme Court on remand. In this case, we see no evidence that the officers either created the Fourth Amendment or threatened, In this case, we see no evidence that the officers either violated the Fourth Amendment or threatened to do so prior to the point when they entered the apartment. This conduct was entirely consistent with the Fourth Amendment, and we are aware of no other evidence that might show that the officers either violated the Fourth Amendment or threatened to do so. For example, by announcing that they would break down the door if the occupants did not open the door voluntarily. Like the court below, we assume for purposes of argument that an exigency existed, Because the officers in this case did not violate or threaten to violate the Fourth Amendment prior to the exigency, we hold that the exigency justified the warrantless search of the apartment.